All right, Keith, we've been out traveling today, visiting with a client up in Orange County, and we just got back to San Diego. And we see that there's another filing made in the Lively versus Baldoni case that's filed in the Southern District of New York. In this filing, it is Lively's attorney, Michael Gottlieb of Wilkie, Farr, and Gallagher. And he is adding a document and asking the court to look at this protective order issue. And there's an issue here about whether there should be attorney's eyes only versus just a confidentiality designation. Maybe we don't know the distinction between those. So if you could walk us through what it is, number one, that they're asking here, what's the reasoning behind this, what's the strategy? And then, what is this attorney's eyes only versus just confidentiality requirement in these types of documents?
Yeah, and if you remember, this all started because Lively wanted texts and calls from Justin Baldoni and the Wayfarer parties. And not only did Baldoni object to that, but his lawyers also recommended or suggested that they enter into a protective order, which is normal. That's something that we use in lawsuits all the time. Where the dispute has come in, apparently, is the designation of documents either being confidential or attorney's eyes only. And the distinction there is that a confidential document, if you mark it confidential, the parties can see those documents. So the parties can see them, the lawyers can see them, certain witnesses can see them, expert witnesses can see them. When you mark something as attorney's eyes only, then only the attorneys can see them, not the parties.
So let me clarify this. So when we're doing discovery in a case generally, and there's documents being exchanged by both sides, generally without a protective order, you can do anything you want with the documents.
Right.
You can give them to who you want. You can use them at deposition. You can use them at trial. You don't have to get special permission to deal with them. But there are certain sensitive documents and cases that come up. And in those cases, you're going to want to enter into a protective order. And not everybody's going to agree, but somebody's going to come forward and say, hey, I want a protective order. Here, Lively saying, not only do we want to use the court's model protective order, we want to add to it, make it stronger. And we want two different types of designations. One is a confidential designation, and one is an attorney's eyes only. And you're saying the primary distinction there is that the attorney's eyes only truly means attorney's eyes only. We don't give them to the parties because this is very sensitive information. Is that right?
Yeah. And so for the obvious example, if you're producing documents in a business litigation case, you might want to mark those documents confidential. But if some of those documents are trade secrets, and as we were discussing this, you mentioned, the recipe for Kentucky Fried Chicken. That would be something that's so sensitive that you'd want to restrict it to attorney's eyes only. You wouldn't want all the parties to be able to see it because it's a highly guarded trade secret. That's where you typically would use attorney's eyes only.
What about social security numbers and financial information?
Medical records, sensitive medical records. And it could also apply to SH complaints if they are embarrassing or sensitive or something like that.
Or what about the person coming forward with the SH complaint? Is that something that attorneys might want to protect as well?
It could be. Yeah. I mean, anything that is really goes beyond just the normal confidential information where you're really afraid and you're concerned about the sensitivity of the information. That's where you get into this attorney eyes only designation.
Did you get a chance to read this letter from Lively's attorneys that dropped this afternoon?
I did.
And what are your thoughts?
So the first argument that they're making, if you just go to the first page, the bottom paragraph there. So essentially what they're saying is that the Wayfarer parties in their opposition argue that the AOE designation is not necessary because of the provisions of the model protective order.
AOE meaning?
AOE meaning attorney's eyes only.
Okay.
So essentially what they're saying is, yeah, but the problem is that the confidential designation doesn't apply to third parties. And so it only applies to information exchanged between the parties. And really what I think is going on here is that Lively wants to make sure, and her team want to make sure that this protective order protects third-party witnesses, like the others that made the HR complaint, right, or any other witnesses. And so that's their first line of argument is this model protective order isn't enough because it doesn't protect other people outside of the parties. And so that's why we need the attorney eyes only designation for that. And if you go down to the second page in the top part of that paragraph, and you'll see that kind of halfway through there, after the M dash, it says, by providing third parties with a way to ensure that their personal sensitive information is accessible only to attorneys who are bound by the rules and ethics of this court and the legal profession, that's the only way to protect these individuals from coming forward. So the argument is these third parties don't want to come forward if they think that their name, their identification, their information is going to be disclosed to the public. And so the only way to make sure that they are willing to come forward is by protecting them.
So let's run through this. Is the idea that that some person is going to, give some salacious evidence to Lively's attorneys, and then the attorneys give that to Team Baldoni, and then Team Baldoni's attorneys give that to their client or to their clients, and then presumably their clients will leak that to YouTubers or anyone else that might take a negative view of this case, and then they're going to do what they've been doing. It's this smear campaign.
What they've alleged to be doing.
Which they've alleged to be doing.
That's what their argument is. But of course, the parties are under this order. I mean, they're under the authority of this order. So if a party were to do that, they'd be in big trouble. But that's the argument.
Okay.
So the second one is Baldoni had said that, look, the model protective order is fine. We don't need anything more than that. And under the model protective order at paragraph 9, it does allow the parties to come to an agreement and designate something as attorney's eyes only if they want to. It doesn't allow each party to designate their own stuff attorney's eyes only, but they can come to an agreement.
Right.
And essentially what the Lively team is arguing here is, well, but we're never going to come to an agreement.
Right.
And so really what this means, if you allow that to go forward, and they use the term, this will be a fait accompli. So they're throwing a little Latin at us here.
When I saw the fait accompli, I remembered my first year of law school and I got scared. So can you walk us through what does a fait accompli mean?
I don't know. I mean, just use normal language, please.
Yes.
There's no reason to get fancy.
Was it a quid pro quo as well?
Yes, I think it was.
Okay.
It was a race judicata.
Okay. That's all three. That's all we got.
Yeah, that's all. Yeah, that's all we have. That's the extent of our Latin. I mean, really what they're saying is that, look, Baldoni's already said that they don't think that this stuff should be confidential because their argument is Lively disclosed a lot of information.
Right.
And so what they're saying is, look, they're never going to agree to mark anything as attorney's eyes only. So we want to have the power to designate it ourselves. I don't know that that's such a great argument. I think that you're going to argue about it either way. So if you have the power to designate something as attorney's eyes only, and it really shouldn't be, you're going to have an argument. You're going to run to the judge and argue.
So let's walk through that under the model protective order. If a party disagrees with the way that you've marked something, if you've marked it confidential, if you've marked it as attorney's eyes only, the other party can object to that and bring it in front of the judge and have an argument. And so how many hearings are we going to have over documents and attorney's eyes only designations if this goes forward?
I mean, potentially dozens and dozens, right? There's going to be endless arguments over what is and what isn't attorney's eyes only. And so I don't know, giving the parties the power to designate their own documents that way, or having it the way the model protective order has it, where the parties have to come together and agree. I think it's 6 of one, half a dozen of another. I think the model protective order really accounts for that. If you think it should be attorney's eyes only, then talk to the other side and work it out. If you can't work it out, then you're going to have to go to the judge.
Okay, and the big distinction here again is if it's only marked confidential, then Baldoni himself, Wayfair, all the plaintiffs and defendants, the parties themselves can look at this stuff with their lawyers. Whereas if it's marked attorney's eyes only the attorneys in the case can look at this. Expert witnesses, can they look at this? What about copy services? Can they look at this if it's marked as attorney's eyes only?
They can. And so that's the thing, is that it is limited to the attorneys, but it's also the attorney's agents would include copy services. So that attorney has to be very careful about who they use, what process they use to do it. It can be very tricky to do that. And then, expert witnesses can also be shown attorney eyes only, but you have to take the steps to safeguard it. And of course, they would have to sign a non-disclosure agreement and all that. But it doesn't keep it from everybody. It just really, the distinction is it keeps it from the parties.
Because the presumption is the parties are going to disclose it to somebody.
That's the fear.
How hard is it to administer an AEO designation?
Well, it depends on the case, right? So it's not that difficult. If it only goes to the attorneys and they don't have to send it out to outside services, then it's not too terribly difficult to administer. But when you start getting expert witnesses involved, copy services involved, then it becomes a real nightmare, or can.
And if somebody from let's say an expert witness has a secretary, and that secretary comes across this information, and I'm not talking poorly about secretaries. Most secretaries are fantastic. I'm just trying to see the hypothetical here and see where the problem may lie. If that expert witness has a secretary who likes to watch TMZ, likes to watch Candace Owens, Megyn Kelly, all the people that are covering this, can they, and they leak that information to somebody, what's the downside to that to the parties in this case, to the lawyers in this case, when something's been marked as attorney's eyes only?
You mean what's the punishment for that?
Is there a punishment? I mean, what do you do?
Yeah, they'd be held in contempt of court, which means they could be fined. They don't typically include any type of jail time, although that would be punitive. The court has the ability to do a penal contempt of court. You have to have a hearing. But the court certainly could issue sanctions. There's also all sorts of discovery sanctions. So, for example, a court has the power under certain circumstances to strike somebody's answer or not allow them to argue or counter argue a point, or take away some of their evidence so they can't use that evidence. Right. So the sanctions that the court has at its discretion, especially in a legal case, it can be quite devastating to a party who violates that order.
Okay.
And then the third argument is kind of the most interesting one. If you go to page 2 at the bottom there, and really what it all comes down to, first of all, they're saying, look, Baldoni's the one who wanted this to begin with. Baldoni wanted the protective order. So he agrees that some of this stuff should be confidential. And so that's the first part of that argument. Okay, well, that's true. Baldoni did ask for the protective order, but not to this level of restriction, but he did ask for one. And then let's go down to page 3. It's the first full paragraph there. At the this is the interesting argument. So certain online content creators who frequently parrot the Wayfarer party's line. So now they're kind of going after everybody here on YouTube who is talking about this case. And they specifically mention like Candace Owens, for example. And I think you saw Perez Hilton in here.
Yes, right here. Perez Hilton.
So, I mean, essentially what they're saying is, well, if we disclose this information and a party gets a hold of it, they're going to feed it out to a YouTuber, and the YouTuber is just going to parrot Baldoni's arguments, because we all have become a manufactured echo chamber. Well, I don't feel like I'm a manufactured echo chamber. I don't feel like you're a manufactured echo chamber.
We're not aware of it. We just are.
That's true. Yeah. We could be dupes.
Yes.
And, we have seen in the previous pleadings that we are in fact dupes.
Yes.
So who knows? I mean, we could be, unsuspecting rubes, but that's their argument, is that this information is going to get out there and all hell is going to break loose for Lively because everybody is parroting the Baldoni's arguments. But let's take a step back here for just a minute and think about, why would a lawyer even want an attorney eyes only designation for this case? What would be a proper purpose for it, and what would be more of an advantage as to why an attorney might want it?
Well, I think people are asking a lot of questions about strategy and how do lawyers devise things? How do lawyers come up with ideas and then try to execute on them? And so what you're asking is, what are the Lively lawyers thinking from a strategic standpoint?
Right.
And what are the Baldoni lawyers thinking in response to this from a strategic standpoint? What are your thoughts?
I think if I was on the Lively side, my strategy would be, there's probably two things that are running through my mind. Number one, I might actually have legitimate complaints and information that is sensitive that I want to make sure is protected. So maybe there is a witness out there who I haven't disclosed yet, who has some HR complaint or some information, and I'm afraid that they're not going to come forward, and I'm afraid that their information is sensitive and will be embarrassing to them. So that would be a legitimate reason for why I would
want. And the protective order, presumably, if signed for attorney's eyes only, would allegedly or potentially protect that person from their identity coming out and from them being run through the circus in YouTube or something along those lines.
The manufactured echo chamber.
Yes.
Yeah. So that would be one reason. But there's a second reason I would want it, which is more of trying to gain an advantage. And look, in every case, lawyers are advocates. So we always, love to be able to gain an advantage where we can. And one of the things could be that, well, maybe I want to produce some information where I think, I don't know, if this got out, it's not all that convincing of evidence. I know I'm going to have to produce it. It's relevant. If the other side makes a document demand of me or serves a subpoena, I'm going to have to produce this evidence. but it's not particularly compelling evidence. And I'm afraid that it would be read the wrong way if it got into the public eye. And so I want the ability to put this extra protection on it for attorney's eyes only. And if I can designate it that way, then at least it starts its life that way. And then we can argue about it. And maybe I can protect it. Maybe I can't, but at least I can try. And lawyers are conservative. We're all conservative people. So once you get the ability to mark something attorney's eyes only, you're going to do it. You're going to do it rather than not do it, because you're going to fall on the side of, I better be careful here and over careful. But that would be something where I would think, maybe I can gain an advantage here by not having to put all my cards on the public table while I'm dealing with this lawsuit and having to produce information out. And there's nothing, inherently unethical about doing that as a lawyer, but it would be something where you're trying to gain an advantage, but you're not coming out and saying it necessarily in the motion.
Yeah, I kind of chuckled. There was a comment the other day with somebody that was talking about the way that we were analyzing this case, and they were saying, I would never hire these lawyers because they're not objective enough. And I hope we don't come off as biased here. I think we're trying to call balls and strikes as we're talking about this. But when you hire a lawyer, Lively's lawyers and Baldoni's lawyers, you don't want them to be objective.
You want them to be advocates.
And you want them to fight. And so what I heard you say was there's a kind of a positive reason why Lively's lawyers might want this. And then there also is more of a strategic way of causing some issues, maybe protecting bad facts. And in many of these cases where we do have attorneys' eyes only designations, isn't that information used for settlement purposes with the hope that it never does come out?
Exactly. Yeah. Anything that's attorney's eyes only can be used at, settlement conferences, mediations, whatever. And so you can show that information and hopefully use it to help, broker a settlement, but you don't have to show it to the parties. And ultimately, the assumption is if it goes to the parties, it goes to the public, I guess. Okay. Is what they're assuming.
So you're in Brian Friedman's shoes. You got this letter today. You're reading it. And of course, you're thinking of the positives that they may be coming at it. Maybe you're not thinking of those at all. You're thinking of the negatives, that these are advocates and they're going to use this to the best of their ability if the court grants it. What are you thinking, and how are you thinking how you're going to respond to this?
Yeah, I'm thinking two things from Friedman's side. Number one, I don't want to get into a situation where the other side is designating everything as attorney's eyes only. Because once you have the power to designate things, then they're going to use it. And like I said, attorneys are conservative people. They're probably going to kind of overuse it. And so I'm thinking, well, great, we're just going to end up with more fights, because then I'm going to have to say, no, that's not attorney's eyes only, or it shouldn't be. You're going to say I'm wrong. And here we are in front of the judge again arguing this stuff. So let's just set this up in a way that's a winning strategy from the beginning and make sure that it works for everybody from the beginning so that we're not constantly going back and arguing this over and over again. I also am thinking, just from a more positive or view towards my client, hey, I want my client to see the evidence. I mean, it's important that the client sees this evidence, both the good and the bad. And so if some evidence comes in that is bad or damning, doesn't my client need to see that? Doesn't that promote settlement if he can see it and see that the bad stuff along with the good stuff? So I would be resistant to wanting to do this type of attorney's eyes only designation. And I would say, look, the protective order, the model protective order, it gives us the right to designate things attorney's eyes only. We just have to come together and agree on it. But we can do that. We can sit and talk. We've already worked some things out as it is, and it's the best that we can do. And so I could see where he would be resistant to wanting this.
Okay, so let me ask you the ultimate question here, and I'm putting you in this judge's shoes. And obviously, there's going to be a response, you would think, coming from Brian Friedman, maybe tomorrow, and we can cover that. But what do you think the judge is going to do with this?
Yeah, it's always an interesting question. I mean, judges like to kind of split the difference and give everybody a little something. I think as a judge, I would really probe the idea of, doesn't the model order already allow for attorney eyes only designation under paragraph 9, and why isn't that sufficient? And I'd really want to hear from Lively's counsel, why isn't that enough? And then I'd also want to know, well, what do you plan to do if the court does grant this? What are you going to do if people have disputes as to what has been designated as attorney's eyes only? Is this going to be hard or easy, or how are you going to resolve those disputes? And listen to that. And ultimately, the judge might allow the attorney's eyes only designation just out of an abundance of caution. But the court might also say, well, the model protective order is there for a reason, so why don't we just stick to that and use it?
Mhm.
So as a judge, if I were the judge in this case, I'd probably be more inclined to say, let's just stick to the model protective order. And then if you guys have problems, come back, we'll talk about it. But we'll have to see how this plays out.
All right. Well, again, we wanted to jump on quickly. We're about 20 minutes into this. We saw this drop as we got back from our trip today. Of course, if anything else drops tomorrow, we can address that as well. And thank you for your keen insight. I really appreciate all the work you're putting into this.
Oh, well, thank you for helping me review this and analyze the motion. That was not an easy read in a very short amount of time, but we got through it and I think we figured it out.
Well, I brushed up on my Latin, so I'm feeling good about that. So
yeah. Hey, I hope everybody learned one more Latin term, fait accompli.
All right. We'll see you guys tomorrow if something drops.